Okay, welcome back to the House Environment Committee. We are about to begin our walkthrough of S212.
This is Mike O'Grady, looking at the as passed by Senate version of S212. The first section is amending the purpose section of the potable water supply and wastewater system chapter. And as the Senate Natural Chair indicated, one of the things that this bill is doing is removing full delegation of water supply and wastewater system permitting to municipalities. And that requires a change in the purpose to the chapter. Because right now, one of the purposes of the chapter is to allow delegation of permitting to municipalities. So that's being replaced with allow review of potable water supply and wastewater system connections pursuant to general permits adopted under this chapter. Because as the chair, Senate Chair also noted, it's my opinion that they don't have the authority currently to issue general permits under this chapter. Moving on to section 2, you're now in the definition section for potable water supply and wastewater systems. You will see those two definitions. They're slightly changing. The first is on page 2, line 4 and 5, and the potable water supply, and clarifying that that includes a service connection to a public water system of any size. Now, later on, you're going to see why it's under potable water supply, because you need a potable water supply permit for connections.
Wow.
Moving down on page 2 and line 12 in the definition of wastewater system. On page 3, you will see the tweak here. Line 1 and 2, sewerage is an antiquated term. The proper term is sanitary sewer collection system. You could also have used wastewater collection system, but that was just an elimination of an antiquated term.
So if you don't mind walking us through this definition, because it's something that I think we should really.
Of wastewater system?
Yes.
So it's any piping, pumping, treatment, or disposal used for conveyance and treatment of sanitary waste, used water, carriage water, processed wastewater. It does not include any internal piping or plumbing, such as pump stations or storage tanks or toilets that are located inside a building or structure. The definition also does not include wastewater systems that are exclusively for treatment and disposal of animal manure. And it refers to a soil-based disposal system of less than 6,500 gallons per day, or that sewer collection connection. So anything over 6,500 has to get an indirect discharge permit. And that is basically regulated as a discharge permit, just like you would have a pipe into a water. You'd need a discharge permit for that. For a soil-based system that's 6,500 gallons or more, you need an indirect discharge permit, and that's under 10 VSA Chapter 47 and not this chapter.
So, what is carriage water?
I believe it's your kitchen water. But I need to look that up to get that specifically.
So do I understand correctly that this is like a town system? And then
No,
this is just your small on-site.
it's a small on-site
Why is the definition in this bill?
because that's what the connections will be. You're connecting your structure to a wastewater system. Because remember,
So so it is the larger town system.
it's the connection that is the larger system. I know it's confusing. Because remember, a connection is basically the same as a septic system. You need the same permit, but there are different standards for that permit. So you have to kind of build into.
What's the definition of the town system? like the treatment plant, I guess. Okay.
That's a public drinking water system that's regulated in a different chapter of law.
I'm talking about sewer treatment plant.
That has different names. That can be a pollution abatement treatment center, or sometimes it's referred to as a wastewater treatment center.
Isn't that what we're connecting to?
Yes, you are. But it's not regulated under those chapters. It's regulated here. And so you kind of have to create that universe that allows regulation of that connection here. Think of it like this. If the connection fails, you have drinking water seeping into the ground, you have wastewater seeping into the ground, you might have wastewater backing up into a structure. It's kind of like when your septic system fails or when your well fails. And that's why it's here, because of the public health and environmental issues, and making sure that they're connected, that they are administered in an appropriate way to avoid those public health and environmental issues.
I think.
Moving on, you come to page 3, section 3. You are in the permits. There's a long list of statutory permits that are required, and there's even more underneath the rules. On page 3, line 5, you'll see except as provided in this section and sections 1974, which are the exemptions from permitting, and 1978, which are the potable water supply and wastewater rules. A person shall obtain a permit for, and you will see line 8 and 9, making a new or modified connection to a new or existing potable water supply or wastewater system. Moving down line 3, line 18, and going on to page 4, this is striking one of the alternatives the legislature tried to implement to address this issue in the past. This was when there was a connection in a designated downtown development district. The municipality could get authority to approve that connection, relying on the certification of a licensed designer. A licensed designer in this world, this universe, is either a licensed engineer or someone who's called a licensed site designer, that they just are allowed to design wastewater systems and potable water supply. So this, as the Senate Chair noted, no town requested this or even, I believe, applied for the ability to do this. So that is being struck. And instead, on page 4, line 12, the bill gives the secretary the authority to adopt a general permit for both potable water supply and wastewater system connections that require a permit. So connection to a new or existing structure. Under the permit, the secretary may give deference to applications for connections certified by a licensed designer. This chapter of law already provides for that, but the agency wanted to be specific in this general permit that they may give deference to the licensed designer. The secretary is going to publish a manual providing guidance to licensed designers implementing the general permit. The manual shall include guidance for determining or defining the capacity of a public water system or pollution abatement facility for purposes of approving a potable water supply or wastewater system connection. So that's the specific general permit, and they shall adopt that general permit. And they may require under that the general permit. Does everybody know what a general permit is? So generally, when there are types of activity that are numerous or common, instead of an agency having to issue an individual permit for each of those common activities, they issue one permit that addresses the common issue. And then the person that wants to take advantage of that applies for notice of coverage. They give the agency notice that they're going to seek coverage under that general permit. And a great example is what's called a stormwater general permit. When you're going to disturb it half an acre or more of earth for any reason except farming, you have to implement stormwater management controls. Do you need to get an individual permit for that? Or can the agency say, these are what the stormwater management controls are when you are disturbing more than and that's what they did. They said, this is what you are going to do when you're disturbing a half acre or more to manage the stormwater off your site. That's basically what every state does. And the people that are subject to it just say, we're seeking coverage underneath that stormwater permit. And then it's an issue of them implementing what is required under that permit. The agency doesn't have to issue an individual permit each time. The applicant doesn't need to submit a administratively complete application. They generally don't have to hire a consultant for that. You know, it reduces time, administrative time, and it reduces costs of compliance. The concern is implementation. And there's always some level of anxiety about a general permit and the people operating under it meeting the standards that are set forth in a general permit. And then there's also anxiety about larger projects or non-common activities and how they're going to be regulated, because that will usually mean a longer administrative time frame and more cost. But it's probably more appropriate for those larger and more complex projects. So that's what a general permit is. And you will see on page 5, line 1 through 3, the bill gives A&R discretionary authority to adopt general permits for other activities, other permits under this chapter for low risk, low impact, and low complexity. So that's usually what general permits are for, that low risk, low complexity, common universe of activities. And I've been asked, well, what's a potential general permit that they could issue other than the connection? Underneath statute and rule, whenever you subdivide land, you're not even going to build on it. You're just going to subdivide it and create parcels. You have to identify a wastewater system area and a replacement area for that each parcel of subdivided land. And you have to get right now an individual permit for that. They could issue a general permit to figure out how you're going to do your identification of your replacement area and your wastewater system area. It's right.
This would allow for that.
This would allow for that. Now, when you build the system and you have the individual site design and site standards, that's probably not going to be a general permit, because most of these systems have these very site-specific issues. And A&R's rule is very health-based and protecting the environment and public health. And so they probably won't go to a general permit for construction of the system, but just for subdividing the land, sure. So moving on from there, on page 5, line 4, section 4, this is that section that previously allowed delegation of the entire potable water supply and wastewater system permitting system to a municipality. The Senate chair noted 2 towns did get delegated, Colchester and Charlotte, and it's just too much. It was too expensive. It was too administratively difficult, required too much staffing. So they surrendered their delegation and they are back underneath A&R's jurisdiction. No other town is interested, and so full delegation has been removed. However, on page 6, line 18 to 21, going on to page 7, there is authority for A&R to delegate connection authority, partial delegation to a municipality to connect potable water supply and municipal wastewater system connections that require a permit under the chapter. But they will have to meet certain standards. They will have to actually own the collection line and wastewater system, because some fire districts located in a municipality, they own their system, and the larger municipality in which they're located doesn't own that system. So a fire district is kind of a misnomer. They're really largely used as water districts, drinking water districts. So a municipality can't apply for delegation for something that they don't own. They have to incorporate the requirements of the Secretary's general permit into their municipal approval, including that deference to the licensed designer. And if they request delegation, they have to have a qualified technical review as determined by AONR, somebody that can do it. They have to get legislative body of the municipality needs to authorize it. So your public works director can't go out and get delegation on their own. They need to meet any other requirement of delegation. And then on page 8, they will only issue permits when there is adequate capacity in the system. And then they have to submit the required documentation to ANR so that there's always one uniform system showing who is permitted and who is not. And that's important for real estate purposes. There's a case law out there that says failure to obtain a state permit is a blight on your title, and that can affect your ability to get real estate insurance and can create anxiety for real estate attorneys. And so they basically, according to professional standards, are supposed to determine what permits you need and whether you have all of them when you are engaged in a real estate transaction. And not all towns are great at or as great as keeping those records. So there's also a backup system at ANR for wastewater and potable water supply permits. So if you can't find that permit, which is required to be filed in your town records, and it's real estate attorney says, I can't find that permit that you're supposed to have, homeowner says, oh, I had it, I got it. They can go to ANR and they can get that permit.
So I have a question. Who owns these lines now? Generally, can you make a generalization about who owns them now?
Municipalities.
They do.
Yeah.
So this is not a new thing. They won't be like, okay.
Right. So what's going to be interesting is some of the community-based indirect discharge systems that are not discharging wastewater into a surface water. They're large mound systems with multiple connections. They most likely will need an indirect discharge permit from ANR, but then how are you going to do connections to them? That's going to be the interesting how that's going to be done, because that's definitely a model that's being proposed and or used in some of the rural areas where there's ledge or other types of restrictions that prevent individual systems.
My understanding of those is that they're built to a certain capacity.
They are.
And the municipalities already figured out
They should have.
how many can connect or how much
Right.
demand can be connected to it.
But I think, I can't remember if it was Warren or Waitsfield,
Waitsfield.
that had to, because of failing systems, close lots, inability to meet the standards, had to put in a community-based system because of the need. And it also allowed for them to do development because they built enough capacity into that system for development.
Yeah, yeah.
Moving on from there, page 8, section 5. This is A&R's fee authority. The first thing that it does on page 9, the municipalities that are conducting the technical review or approval, they'll still be able to charge a fee for that cost. Even though will technically be a delegated state permit, they'll still be able to charge their fees. But they're going to have to pay a $100 processing fee to A&R when they submit their documentation. Remember, A&R is going to keep the record to maintain that uniform system of recording. That means that some staff person is going to have to accept these and record them, and they're going to charge a $100 fee for that. And then going on to page 10, this is really, I want to point out what the fees are right now for your potable water supply and wastewater system permits. You will see that they're based on design flow, and you will see that they go up to about $13,500. So that's what the existing permit fees are. But then on page 11, because these are going to be not for those really difficult, really large systems, they're going to have a kind of consolidated fee structure. So design flows below 2,000 gallons per day, it's going to be $250. Design flows between 2,000 and 6,500, it's 2,500. And then design flows greater than 6,500 is 5,000. So those fees are all less than what the corresponding fee would be for an individual permit. And it will help with cost and processing.
Right, these are fees that currently, the current statute that you have here cited, those are going to the state for connection to a town system?
Yes.
And then the town would also,
The town might also have its own fee.
I'm not understanding how the fee to the state is based on flows, because it seems like the flow-based fee would go to the entity providing the service, because other service users have paid for it and you're paying your share when you attach. How did that, do you know how this ended up going to the state based on gallons per day?
I mean, it's, as I've been here, it's always been on the books. And
Seems like the cost to the state isn't gallons per day, it's staff to oversee the program.
right, and to determine whether or not a larger system is meeting standards.
But then the town also charges based presumably on gallons per day. That's.
And some towns, you should talk to the towns about what they charge for their connections, because it's very variable.
Yeah, I bet. Yeah.
Because this is a land use tool as well as an environmental health tool.
Also, just kind of the fairness thing gets into the like last one in kind of concept of who's paying and when for the service provided. Anyway.
So moving on to page 11, this is really just an implementation section. It directs A&R to adopt that general permit by December 1, 2027. And then the manual, and then beginning January 1, 2028, they'll begin to accept certifications of connections under the general permit. And then page 12, going on to page 13, there are provisions in A&R's rules that deal with full delegation, that deal with types of connection exceptions that are no longer going to be relevant. all of those rules that are no longer relevant are repealed. And then the effective date of the whole bill is July 2026.
Representative Austin.
Yeah, just a kind of a selfish question for Colchester. If Colchester is putting in a municipal system now, would these fees be retroactive? If it's not going to be completed till 2027?
No,
No.
no.
Nora.
Yeah, since we're talking, thank you, Madam Chair, and Michael, since we're talking about a delegated partial delegation, not a fully delegated, but partially delegated. Oh, are these fees the same as if it were fully delegated?
So these fees don't exist. The general permit fees don't exist now.
You said that that's the way it's always been ever since you.
Well, there's, for the individual permits, those fees
These fees the same as those individual permit fees
for delegation.
or fully delegated.
I don't know in the fully delegated municipalities that they were charging different fees. I don't know that.
If it's not delegated, and these are the fees that are charged, then if we're partially delegating something, we should charge like half the fee.
Right, and the municipality will be charging that fee, but then they're gonna have to pay $100 permit and processing fee to A&R for the recording of the fee. The recording of the permit.
Yeah,
You should,
so we got regular permitting where there's no delegation and A&R is going to charge fees.
yeah, yeah,
Now they're delegating part of it.
partial delegation,
The person applying, the applicant, has to pay these fees.
right, and
Fees both to A&R and to the municipality.
when there's partial delegation, you're paying the municipality.
These fees.
I don't know. It's probably gonna be different. It's probably gonna be the municipality that comes up with their own
Sure.
fee,
Understand that. That's the fees you're paying, but we're still charging fees to.
but only $100.
So what is this, all this on page 10?
That's for general permits that A&R is issuing the coverage under. All right, so
Page 10 or 11. So the 11 is the new language. That's the general permit, I think.
the general permit isn't just for those partially delegated. The general permit is for any connection across the state. And you're gonna pay those permits to A&R. But if you, the town, get partially delegated, you run your program. The fee is paid to you and you pay a recording fee to A&R to record your permit in their permitting system.
No per gallon fee,
No fee to A&R.
per gallon fee to A&R. Okay, so these fees are only for the general permit fee, not for
The
the.
partially delegated town.
Yeah,
Sorry, I'm just.
I think it's confusing. Well,
Well, take away partial delegations, pretend that partial delegation doesn't exist. This is a general permit for an A&R permit. And you pay to A&R a fee for an A&R permit.
That fee is based on a per gallon.
And that is right now a per gallon, gallons per day fee.
Even though,
did the Senate explore that question of why is it scaled to per gallons when it's going to the state who doesn't presumably pay for the system?
I don't recollect them going to that level. And so there's your A&R general permit fee to A&R. Now, the town can come along and get partially delegated to do connections. They're now the one issuing the permit. They're the one charging the fee. They're the one that sets the fee. I can't say what the fee is going to be. But they had to give A&R documentation of any of their approved connections with a $100 recording fee.
Okay, so in that case, the applicant is operating under two permits, the general A and R permit and the municipal delegated permit. They gotta have both of those and they're paying fees to both.
Under partial delegation?
Yes.
No, they are paying a permit fee to the partially delegated town.
But they
the
couldn't,
general-
they couldn't have gotten to that point without the general permit from A and R to start with.
The general permit is incorporated into the partial delegation. See that on page 7. Lines 3 through 5, municipalities' delegated authority shall be required to incorporate the requirements of the Secretary's general permit into a municipal connection approval. So you consolidated into the municipal approval. A&R is not approving anything, but the general permit requirements have to be part of that municipal approval.
But you're not. The applicant is not getting a separate A and R
They're
general.
not getting a separate A&R permit.
That's what I was missing.
In a non-delegated town, they might need to get both approvals. Because in a non-delegated town, this might be part of your zoning permit to get your connection approved.
And then you have to do both, an A and R general permit and a municipal permit to connect, if you're non-delegated.
You might have to get both because it's probably part of your zoning permit.
So how involved were the towns in this conversation? Do you know?
I mean, they talk to towns, they talk to Stowe, they talk to, I can't remember.
I mean, considering we've tried this a few times and the towns haven't bit on any of the ways we've tried this, what assurances might we have that they will be interested in this deal?
In delegation, partial delegation? Well, the only town I know that expressed interest in that was Burlington. And
We have a.
they have a public works system and a public works director that is pretty good. And she knows what she's doing. She thinks she can probably run this program.
So we're constructing legislation for Burlington that Burlington can use and nobody else can.
No, others, I mean, remember Colchester and Charlotte
And South Burlington.
ran the whole program, right? But the problem is not the connections. The problem is like, when do I need a mound system and near the lake? And does the town really want to be arguing with the Canadian property owner about that? And, and like that just got too much for those towns. But connections, you might get a licensed designer on your staff that's going to go out and do that. And maybe that's easier for your development.
I ask this particular case, again, selfishly.
Well, Colchester's going to South Burlington. So South Burlington says it has to do with the number of bedrooms, people's houses, and that determines what capacity they can apply for the sewer. And the people who are getting charged are the people who are hooking up. Otherwise it was through federal and state grants.
Is Vergennes a delegated town? They're looking at maybe being the first user of the CHIP program, putting in a 74 unit development on town property. Extend, and in doing so, extending the town sewer and town water to this. Are they gonna have to, are they gonna be delegated, or are they gonna operate under two permits?
It's up to the town to apply for the partial delegation.
Any town can apply for it, but it'll be towns that have staff to
Yeah.
administer.
You have a treatment, does,
Yeah,
you do, oh, good. I didn't know
Where's it going?
And new police station. Across from Kennedy Road.
that.
Okay. It's just like an open field right now, isn't it?
No, it's a kind of a constrained area. 22A goes through there, railroad tracks go
Right.
across, police station, and then there's wetlands and stuff. And so it's a little piece of property in there that just about fits. It's like 10 acres. Ish.
Representative Austin?
Yeah, was there any discussion in the Senate about maintenance? Like, I know my system I have to have someone inspect it every year and turn the inspection form into the town. Is there any regulation that everybody has to do that, or is that up to the municipality?
That's not required right now for septic systems under state rule. You do need to ensure that your connections are working properly, and you normally know when they're not. Because you experience things like low water pressure or wastewater systems that back up or aren't working.
Shift topics one more time.
Pardon?
We'll shift topics one more time.
Okay.
You booked up. Sorry.
I need a hearing aid. Need a hearing aid.
No, we have to talk.
Degradation, Mike.
Yeah.
Which year?
So I was asked to talk about the difference between what is an affirmative defense underneath S218, the chloride contamination bill. And there should be on your committee webpage, this document comparing an affirmative defense to what was initially in S29 from last year. Remember, there was a salt bill, chloride contamination bill last year, and when that was introduced, it had an immunity provision in it. It said that the municipal salt applicator or the commercial salt applicator shall not be liable. But now there was discussion last year in the judiciary committees about what that meant. There were concerns from advocates about prohibiting people from going to court or seeking a remedy if they were hurt. And so the judiciary committees last year, Senate Judiciary, House Judiciary, instead of it being an immunity, shall not be liable, on page 2, said that commercial applicator and later on the municipal applicator shall have an affirmative defense against the claim for damages resulting from a hazard caused by snow or ice. Now, what is the difference? So the difference is largely on page 3, and I'm sorry I didn't put page numbers on this.
Representative Chapin has a question.
Sorry to interrupt you, Michael. The bill we looked at, you're comparing this to the first Senate bill?
Yes.
To remind the committee, the bill we looked at did not have absolute immunity. It had limited liability. So I think it'd be more helpful to compare what's in this bill to what we passed last year versus what the Senate maybe started with.
I don't really recall what came out of this committee. It really doesn't matter because it's really the distinction between an affirmative defense and immunity or qualified immunity.
So I just wanted to then just remind the committee that we discussed and heard testimony about and passed was about limited liability, but there was concerns on the House side with that. Although we did think we were moving it forward, and then the Senate, I guess, started with something.
So think of it like this: limited immunity, qualified immunity, absolute immunity, whatever you want, however you want to characterize it. It prohibits the claim. It doesn't allow the claim to be brought. So say somebody is injured, they bring a claim against the commercial applicator. At that stage, the commercial applicator moves to dismiss the claim because there is no claim. And so then the judge looks at the statute and says, yes, there's either absolute immunity or qualified immunity, or if you want to call qualified immunity limited liability, it's effectively the same. What's an example of absolute immunity? You have absolute immunity. You all have absolute immunity for those actions you take within your legislative sphere. So you can go out there on the House floor and you can say a lot of things, and no one has the ability to bring suit against you for what you say or what you do within your legislative sphere. So if somebody did sue you at that pleading, at that first hearing on the complaint, your attorney would move to dismiss the claim for absolute immunity. Now, qualified immunity is you have to show some things in order to get that immunity. And for example, last year, in one of the versions, you had to show that, hey, you were trained, that you were applying according to BMPs, the injury was caused solely by snow or ice, and that hazard was caused by you following the BMPs. And if you showed that in your motion, then the court dismisses the claim. No more claim, nothing, right? And that is basically the plaintiff's burden to show that absolute immunity or qualified immunity does not apply. It's on the plaintiff to show that they have a claim. Affirmative defense flips that dynamic. Affirmative defense is a pleading. So there's a claim brought by an injured person at the pleading. The defendant, the commercial applicator, says, I have an affirmative defense to this claim. I admit that I was applying salt or salt alternatives, but because I was certified, because I was following the BMPs, and because the injury was caused solely by the snow or ice that wasn't removed because I was following the BMPs, I am not liable. It happened. The act happened. The claim can be brought, but now it's on the defendant to show that they qualify for the affirmative defense. The plaintiff gets to bring their claim. Gets to say, I was injured, gets to say it was because of the negligence, because of their failures. And the defendant says, yes, I did that. I did apply salt there. Yes, there may have been an injury, but I am not liable because I did all of these things that I was required to do in order to get the affirmative defense. Now, certain advocates like this model because it allows that person that's harmed to get into a court action, to have that opportunity to make their arguments like, no, they weren't following the BMPs. No, they weren't recording properly their applications, etc. So instead of the court saying, no, they're immune, you can't bring a claim against them, the court says, you can bring a claim, but there's an affirmative defense that the defendant has to prove. And that is the difference. That's largely the difference. In the end, if you prove your affirmative defense, you're immunized. But you have to go, you're not immunized, you are free of liability. But you have to go through that process of proving your eligibility for the affirmative defense instead of the plaintiff proving that you are not immune.
Do we know what standard New Hampshire's using?
They have shall not be liable.
So they have,
And that was part of what the advocates were arguing. The advocates were arguing that New Hampshire plaintiffs And they talked to New Hampshire, talked to the trial bar in New Hampshire that was a problem for them. That was a problem for those plaintiffs that were injured and that were not allowed to seek redress because of that shall not be liable. And that's why the judiciary committees, well, not just New Hampshire, it was the advocates here arguing for that opportunity for the injured party to go to court and make an argument.
Okay, thank you. Yes. Members have any further questions? Representative Chapin.
Because I was preparing to, a year ago, talk about the limited liability. So just an affirmative defense. So there's still, in both limited liability and affirmative defense, there's still a sort of a list of parameters that if you meet, you're not liable. In affirmative defense, it's the defense that has to prove that to the judge.
Right.
Or whoever. And in limited liability, it's on the claimant or the.
Right. It's kind of a procedural for limited liability and we're qualified immunity because the action is filed, right? And your attorney responds, the defendant's attorney responds with a motion to dismiss and says, I've met all of these. And then your plaintiff says, well, no, you haven't. And so the court then holds basically it's not really a trial. It's kind of like a factual determination hearing and determines whether or not those facts have been met and then says that they've been met, you're immunized and you're gone. The other way, it's the defendant responds with their pleading and says, I have an affirmative defense. And then that's going to go to a fact finder. And that fact finder is basically a trial or a judge bench trial. And then you're going to have the back and forth. And so it really is the level of kind of credence that a judge gives in that immunity factual determination. They might have a hearing, they might go to a summary judgment proceeding effectively where they determine if there's any factual issues at issue. And that's the type of thing that would happen. But that plaintiff gets into the court with the affirmative defense and they may not get into the court with the immunity.
So I'm hearing with the limited liability versus the affirmative defense, the affirmative defense not only places the burden on the defense, but it also gives the plaintiff more of a chance in front of the judge.
Yes.
To be able to rebut.
Yes.
Okay, so who pays for the defense of the defendant if they do go to court?
The defendant.
The defendant pays, for it, not the municipality or their.
Well, I mean, if the defendant is a commercial applicator, the commercial applicator is going to pay. If the defendant is the municipality, the municipality is going to pay. The municipal employee there's a statute that you probably heard the league talk to you about that says the town is immune, but the employee is not, but the town has to represent the employee and potentially assume the employee's liability, which the league doesn't like that at all. And so the municipality, not the league.
Yeah.
Thank you, Michael.
Great, thanks.
Are you set, ready to join us, Representative Kim?
Ready.
Great,
Madam Chair.
please do. So we are,
Thank you.
yeah. Your amendment? Oh, good.
Good morning. My name is Charlie Kimball, representative from Woodstock, Reading, and Plymouth. Here to talk about the House Ways and Means Amendment to H 928. And I don't want to jinx it by saying this is a very simple amendment, but just to tell you where we're coming from with it. You will see something in the miscellaneous tax bill, which is H 933, which addresses the fees being charged by the Department of Fish and Wildlife. And that mostly started in reaction to when the Department of Fish and Wildlife wanted to charge a $20 conservation license to access wildlife management areas. We felt that in that process, we had unfairly delegated the authority of the legislature to the Department of Fish and Wildlife and said we want to regain that authority. As you know, most fees are set by the legislature. We're typically before the Scott administration had a fee bill every year and would be looking at those fees that are charged to consumers, and those are set by the legislature. So in that time, there was one particular set of fees, I think it's the Green Mountain Conservation Camps, and also for use and tuition for those that we've delegated to the Agency of Natural Resources, Department of Fish and Wildlife, and we feel comfortable with that. But the other fees, we were not comfortable necessarily delegating that authority. So when this bill came to us, we looked at what the fee was for the extension of what we understand to be an additional license for taking a big game. Mostly we heard about it in relation to does, with the idea of managing the doe herd, but also in relation to turkeys. So my committee is not the expert in this area. We were kind of surprised, some of us, that turkeys were considered big game, but nonetheless.
They are considered big game in the state of Vermont. New York considers them small game.
Confirmation of big game at the,
Right.
when we voted this, and I don't remember turkeys being on that confirmation from the department.
Yeah.
That's too.
So our amendment is fairly simple. It's only one instance of amendment, and that is in, tell you what the section, section 3, and license fees. And that we're adding language that says basically the department may issue such tags and permits and may assess a provisional fee for such tags and permits of not more than the lowest fee for a big game tag as provided in subsection A of the section. And then to come back to the legislature, seek legislative approval of the fees pursuant to 32 VSA 603 within 1 year following the department's assessment of the fee. So trying to, again, come back and say, let us approve the fees that you're charging. We understand this is a fluid situation, but we want to have our eyes on it when the fees are charged. That's basically it.
Thank you. Do members have questions? Representative Pritchard.
Yeah, so here's my question, and I'm gonna ask this before I ask. That'll depend on the answer, will depend on whether I ask Charlie a question. If this was to come back and there be disagreement on this amendment, what does that do to this bill? I mean, will this stop this bill from moving to the Senate? Is there a timeline on? I know I'm supposed to present it tomorrow.
That's not for me, right?
Yeah, that. So is there a timeline on when we need to respond to this amendment? Yes.
If we delay this from going to the floor tomorrow, does that change this bill being able to continue going forward?
We can always postpone action if we find we need to, but if we want the bill to go forward, it can only postpone so long and have the bill go forward.
Something was pointed out to me, Madam Chair, on my way here, that the specific language we used, which says to charge the lowest fee for big game, on here there is a bear tag fee for $5. It was not our intent to say $5.
Got my eyes.
That's what my concern is.
Okay, so
And that's why I had gone to Representative Canfield, talked to him, and I actually gone to Chair Kornheiser, spoke to her and showed her the language, which she seemed to be fine with. Because she was confusing this with the WMA stamp
Yes.
issue.
Yes.
So two entirely different issues. So I thought, what we had talked about was we weren't going to be raising costs. We had, the way our language said, the prevailing rate of the big game fee. We had all talked about a $23 fee, which is what the normal fees are for the archery license, the deer, all the tags, with the exception of the additional bear tag. And why it landed there is disappointing.
Well, we're working through that now. So, but the sort of, if I may, the kind of, anyway, the gist of what you all are getting at is that they come back
Yes,
for the approval,
Yes.
not which number we're lining this up with. So
that's right.
we can fix that problem.
Yeah.
Do you have thoughts on that?
We could do a further instance of amendment. I have not talked to the chair about that. As I said, it was on my way here that I learned of it. But we voted it out by a vote. Oh, I can't quote the actual vote. I'm not, sorry. I think it was a 10-0-1, but I'm not positive. I apologize for not being able to quote that right now.
And I know you all do lots of bill reviews. Representative Taglio.
Couple questions. Thank you. It just seems to me the way this is written, it sounds like Ways and Means is willing to forego revenue, and why would that be? This looks like
Oh, I see, by going to the lowest amount of the fee.
yeah, something based on market value. So why would you be willing to leave money on the table, especially for a division that is always so they're running on
Fair enough.
a strength?
Yeah.
The other question is, I thought some of these fees, the commissioner was looking for the leeway because of when we're in session versus when the time comes to actually assess these fees, and we would be missing out on years when some of these tags or permits would be issued.
Yeah, I think the intent of the committee was more to have review of the fees and to have that authority and not to delegate that authority in perpetuity. And that there obviously are times when they do have to make decisions, and that was, I think, the case with the doe season, the way it was run. Again, not expert on that, jurisdictional experts. So it's more about, our concern is more about the approval of the fees and not delegating that authority. As to the level of the fees, I'm sure we would be able to talk together on that.
Just to push back a little if I could, these
Well-
fees would not be in perpetuity. We're here once a year. So that if there was something that Ways and Means didn't like, we could always revisit next year.
Well, right, but we don't want to permanently delegate any authority. Yeah.
And don't in other areas.
Yeah.
It's important for
That's right.
people to know. Representative Norton.
Thank you, Madam Chair. Just, Charlie, I wanted to understand how you see the timeline of this working. Based on the sentence, it says the department shall seek legislative approval of a provisional fee pursuant that's within 1 year of the department's assessment of the fee. So it's kind of time sensitive. So they do the assessment of the herd. This is all out, past the legislative session. They've got to come up with a new fee for this new additional tag. Oh, we're going to allow two tags this year. So they kind of have to do it like right then and there.
Yeah.
So they assess $23 fee or, whatever, and people pay it. Then 1 year later, we come around and go, nah, you weren't supposed to charge that fee. Now do you see everybody having to pay back all the fees that were collected after the 1 year, after the legislature says, no, you shouldn't have charged $23 for that. You should have only charged $5 for that.
No, thank you for that.
Everybody, I understand the time.
That's certainly not the intent. I mean, the next sentence, the department's failure to obtain approval of the provisional fee shall void the provisional fee, and the department shall not assess a new provisional fee for the same big game. So it's really looking forward after that. So it's not going to say you get a refund on all those things. So within a year gives the department a new legislative session to come to and get approval for that.
Okay, and then in the next year, the department reanalyzes and says, oh, now we get 3. tags, and we're gonna charge $40 for that third one.
Yeah.
And then you go around another year, but so then how does the discussion from the first year apply to this now second year that we're. I'm just trying to understand the timeline, and we're gonna get all bollock stuff with one another with provisional fees and then the approved fee and then which fee applies.
Yeah, I don't think it doesn't happen that often, first, and it actually speaks to why we don't want to always delegate that authority. So we want to review the fees on a regular basis that the department is charging. Unless we want the department to have that authority and kind of always be,
The authority, the delegated, what we're considering, I think what this language does is give delegated authority to the department for basically for 1 year.
yes,
And whatever they did during that 1 year is good. We're not gonna go back and try to change it.
that's right.
And then the next year, we're gonna look at and say.
That's still gonna be in
how would that
place.
be applied going forward.
Right. Right.
That's not clear to me in this language.
Michael O'Grady, I think drafted it.
Bradley.
Bradley, yeah.
Yeah, I guess especially the use of the word provisional, the provisional fee, that means like. It's still in question, we're gonna charge it to you, but.
Means it hasn't been passed in statute.
Yeah, exactly, so are refunds gonna be due, and to me, that's not super clear. But if it actually stands for the year, and then you don't look back. Yes, some cleanup around that would be helpful, if that's the way it's intended to operate.
Not sure what the wording would be, but
You think it's clear the way it is?
I do. I think that part is clear, and I just am curious if the Ways and Means Committee can reconsider the lowest amount language.
yeah, and I think that if we're looking at it, we didn't want to necessarily hamstring the department. So if there was a fee for $5, I'm not sure why the bear tag fee is only $5.
That's an additional tag.
Okay. Okay,
When you purchase the license, you get a late season tag. They have a early season, and you would have to purchase that if you want to participate in the early season. So that's what that tag is for.
That's a valid question, though. Why is the bear tag $5 when every other tag is more? But it is, and so just curious about the chance to go on the lower end. Particularly given that the two that we've heard about are a deer tag, excuse me, and a turkey tag, both of which are
$23.
23. So
And archery and a muzzleloader, they're all 23. All the additional tags are $23. I think part of the
in the middle.
too is not only that we're not in session, but when the Fish and Wildlife also has to print the rule book. And they're on a timeline to do that. And that's really what happened this year.
Yeah,
They couldn't get it in the rules about this additional tag and how much it was going to cost.
yeah.
So they were left to give it for nothing.
Well, I think this does kind of splits the difference. I think what we're hearing is our Ways and Means Committee feels very strongly about keeping the ability to levy fees in the legislature's purview. And this is them trying to meet the department and provide that flexibility.
Yeah.
Another way to look at this. Representative Tagliavia.
I just wanted to point out that this tag, this fee is part of a management tool, one of the many management tools for managing the herd. It's not only about the money. And when you have changes to the management of the herd, that needs to be taken into consideration. And I'm not sure that Ways and Means is concerned about herd management when they're thinking about these numbers.
Well, it comes back to what do you charge a fee for? You're either trying to recover costs, you're trying to change behavior, or trying to generate income. And so when you're ever charging a fee, if the Department of Fish and Wildlife said, we want to charge $5 only because we really have a big problem here, then they could have a $5 fee because it meets up with their needs. So we question every fee that we review as to why that's being charged and why that. We're looking at the mileage-based user fee right now for electric vehicles with the same type of thing in mind. why are we charging this fee? How much? What is it going to do to consumer behavior? So we would ask the same questions with that. So I don't know that $5 is the right amount for a bear tag. Or the department may consider, we're going to charge $300 for a particular fee, which seems outrageous, but because it meets some kind of departmental goal at that time. So that's why, really thinking about it, that's why it was the $5, the lowest fee for that, because they might have a reason to charge a low fee that we don't know.
The prevailing would allow them to do that and not exceed it, though.
I'm not sure what prevailing means in that sense.
What the present rate is, the prevailing rate.
But
Right now, it's $23. If it was 2 years from now, if it was $30, then they wouldn't be able to charge any more than what people are paying for it now. So
But-
they're really not raising any fees.
And the prevailing, it goes $100 for a moose license, $5 for a bear tag, $23 for the others. Would you be more comfortable with $23 instead of prevailing rate?
That's what the prevailing rate is for deer tags.
Okay, but it doesn't say deer tags.
Right.
It was not limited to deer tags.
Isn't qualified to
Yeah.
that type of game.
No,
Okay, well, we could
It was
qualify
to
to
big
that
game, I think.
Well, it was big, I think it was qualified to big game.
big game, right, which includes
5 to
moose,
100.
turkeys, gears, deer, bear.
Representative Sacraments.
Yeah, this is for 1 year while before it comes back to us.
Yeah.
And so I do think $5 is probably too low, and I think I would trust the commissioner to just be able to set the fee for that 1 year, knowing that the commissioner is unlikely to set it extremely low or extremely high, and is probably going to try and find an analogous or existing fee to base it on. And if the commissioner did really in some world really mess that up, it's just going to be for 1 year, and then we'll fix it when it comes back.
That seems like a good solution.
Do you think that you would be able to take that request back to your committee?
I'll certainly discuss it with our committee as to whether or not we should change it. We passed it, it's on notice. As to whether or not we would amend, or would you want to amend our report? That's a good question. It's an option for
That out.
us, yeah. If I understand what you are saying is that it's not to make it the lowest fee, but to make it so that it is at least, as you said, the prevailing fee, but
I guess for us, it meant lined up with the animal being taken.
Right.
The prevailing fee for the animal being licensed.
okay,
You pay this much
That's
for
what
a
that meant to
turkey.
us, and I understand that if we had the same conversation actually, and we were like, well, we're gonna trust that that's gonna be, if it's a deer, it's gonna be no more than 23
okay, all right.
for a turkey. Yeah.
Certainly discuss it with them as to whether it's you or us doing it. Good question.
Representative Chapin.
But, sorry, you're just not confirming what I just heard, which is a suggestion to just take that out at all, what the fee should be, and just enable them to make a fee, and then we'll review it. Or it'll go away. So maybe the best solution is for
different things.
whoever's gonna make the amendment, to make the amendment, just to take that part of that out, because.
As to what the fee is.
You've made it just temporary. It's a really different conversation, I think, for our committee.
Yeah.
As to how much we wanna control what fee they initially set it at.
Right.
Now, that's sort of moot.
Yeah.
Yeah. Yep.
So, because our concern was, aren't we supposed to be setting fees? We're enabling them to set a fee.
So we were putting a boundary on it because of that, but then you, because you see this larger picture, yeah, brought in a different idea.
So
That's right.
I'd propose that that be whatever we come to.
That we strike
Final amendment.
The limit because we're having a check back.
Yeah, right.
Interesting. Yeah. All right, we will talk amongst ourselves and
Okay.
path forward.
Amongst yourselves.
Thank you. Thank you, Chair.
Thank you, Charlie. Okay, well, I think we agree that that's our preferred choice. And so find a path forward with the Ways and Means Committee on how to
Work that out.
how to do that. Yeah, we'll work it out. I mean, I'll work with Representative Pritchard on. So with that, I think we're adjourned.